Welcome to today's eESI podcast as we continue our series on practical HR tips for managers. In this three-part series, we've covered identifying the risks, the reluctant manager, and today, HR, why it's so hard. Our special guest is Karla Saenz. Karla is an HR business partner with eESI with PHR and SHRM certifications. She's been in the PEO industry for 20 years. She knows HR. Welcome, Karla.
Thanks for having me.
Well, let's talk about why it is so hard, HR.
I think there's a few things that make it hard. One, business owner has to trust that they've hired the right person for the job. So the person that they've hired to manage their employees knows about the employment laws and knows what it entails to have a workforce. And then the managers need to understand that what they do is seen as what the organization is doing. When they speak, the organization speaks. And that there are labor laws to adhere to. So depending on how many employees you have, you may be a covered employer for one or more labor laws. And of course, as your employee count changes, the labor laws that apply to you may change as well. And if you work in multiple locations, you have to understand the laws in those states. And in some cases, in a municipality, for example, Austin recently had a ban the box law that just went through. So if you have employees in Austin, whether it's one or many, you have to know that your application has to be different in that city.
Well, what are some of the more difficult issues that you can shed some light on for managers?
Well, so the laws aren't new. This isn't anything new, but it's difficult if you don't do it every day. So when you see big organizations in the news, it kind of gets your attention. One that comes to mind is the EEOC suing Shipley Donuts, a franchise here in Katy, Texas. The owner of this franchise heard through other employees that a female employee was pregnant. So he took it upon himself to have a confrontation with this employee, and he asked her intrusive personal questions about whether or not she's pregnant. The employee refused to answer. So the employer tells her, well, okay, you're not going to answer. What I'm going to do is I'm going to take you off the schedule until you can provide a doctor's note that does two things. One, it tells us that you're allowed to work, and secondly, assures that Shipley's has an employee without a high-risk pregnancy. So this employee, of course, what most employees would do is they're concerned about this. She's off the schedule, which means no pay. So she goes home. She shares that with her mother. So her mother's concerned and calls the owner on her daughter's behalf and says, hey, I found out what you asked my daughter about, and she starts questioning the legality of this release, right? Well, the next day, the employee gets a call from her manager telling her she's being terminated for not showing up to work, which is confusing to her because she was just told the day before by the owner of the business that she's not to come to work until she can produce this doctor's note. So that is what led to her going to the EEOC and filing a claim of retaliation and discrimination due to pregnancy.
And what happened there?
It's still ongoing. So that was in 2014. It's ongoing, but what the EEOC is saying that they're looking for in this case is to have back pay for the employee, including interest. They are also looking to raise awareness. So what they can do is require that this employer have some training or even assign people to do that training for them, that they're looking for compensatory damages and punitive damages in this case.
So when the EEOC comes after you, if you don't understand something, it really can get expensive because they're trying to make an example out of you as well. Is that what you're saying?
Yes. And then, again, to understand, he may well have wanted to know if she was high risk, but not to act on rumors the way he did. The EEOC has said in this case that the employee, in this case the female employee, is up to her to decide whether or not she can work, right? So she would have had to come to her employer and say, hey, I'm pregnant, and because of that, I need an accommodation, or because of that, I need to be off the schedule for a while.
My next question was going to be, is it illegal to ask someone if they're pregnant? In this case, the Pregnancy Discrimination Act. If you're a manager, you understand it, you know how to handle that, and you know the kind of things you can't ask, and you also know what you can or can't do, and that can prevent you from having to deal with some very expensive fines and, in some cases, lawsuits. What is another issue that can be a thorny issue?
Well, again, we talked about earlier is, when the manager speaks, the law sees it as the organization speaking. Another case that comes to mind is a recent one that was just settled last year with Bass Pro. The settlement was for $10.5 million, and that was to settle a discrimination and retaliation suit. So this one actually started in 2011. That's the first time the EEOC filed this charge against Bass Pro. So it just settled in 2017, so 6 years they were working on this. They claimed that Bass Pro unlawfully retaliated against workers who opposed discriminatory practices in hiring. So this is an employee or manager here in Katy, Texas that said, hey, I don't see that you're hiring enough African Americans or Hispanics, and she spoke up about it. And so this isn't someone that was affected by it. She just opposed it. So she wasn't being discriminated against herself. She just spoke up. Some of the alleged things that they did, one example is a manager said, "It's getting a little dark in here. You need to hire some white people." And that's one of many things that were in this lawsuit.
It wasn't a matter of someone being offended unjustly. They had heard comments that clearly showed that there was discrimination going on. Quite a judgment, $10.5 million. What's the point from that, from the Civil Rights Act? What do you need to know about that?
Well, it's important to know that it doesn't just apply when they're an employee. So, again, this is talking about hiring practices. So this person saying, "Hey, I don't think we hire enough minorities." So what were they doing wrong? At the moment you place that job ad, you got to make sure your wording is right. And then when you start looking at resumes or applications, you got to make sure that there's no bias, right? That if you're not looking at for example, on a Hispanic last name and saying, "I doubt they're authorized to work, so I'm not going to even call them in for an interview." You want to make sure that you understand this applies at the moment you place that job ad and start looking at applicants.
So the issue is not that they have to hire a certain number of Black or Hispanic employees. The issue is just that you can't specifically look to exclude them, which is what Bass Pro was doing and what the EEOC found as they looked into the case. Is that correct?
That's correct. So part of that settlement that we talked about, the 10.5, included other things. Some of it, you might be interested to know that the compensation was for eligible Black and Hispanic job seekers who were not hired. So part of that settlement was the people who were not even employees. They also have agreed to update their EEO policies and their hiring practices and to post job openings at schools with significant minority population.
Well, then I wonder about that. Does that mean that they have to go out of their way to try to find Hispanics and minorities?
Not so much go out of their way to do it, but make sure they're making a good effort to do it, to not exclude them, to make sure that they give them equal opportunity even in the hiring and then promoting.
If Bass Pro had not purposefully gone out of their way to avoid Black and Hispanic employees, but they just put ads out in the public newspapers or Indeed or any of the other different sites looking for employees, and as a result, they had a workforce that didn't quite look like the general population. Maybe instead of 40% minority, it was 32 or 28%, but it wasn't intentional. Would they have been, or could they have been fined?
The key here is they have to make sure that they have a good candidate pool, right, of qualified applicants. So in the Bass Pro case, they found that there were applicants that were minorities that were qualified, but they were not hired.
Okay.
Because of their national origin or because of their race, right? So they're overlooking qualified applicants. So there's not a real good reason for that, right? So if someone's qualified to do the job, you're looking at their application, looks good, and then when you see them in person, you discover, they're either Hispanic or they are African American, and that's the basis for you not hiring someone. That's where you get into trouble with the EEOC.
Karla, it just seems so strange that a company as large as Bass Pro would actually make comments like, "It's getting dark in here, we need to hire more white people." It just seems like you're opening yourself up to a lawsuit. I'm surprised that they didn't know any better. Was that a low-level manager that just wasn't trained well, or was that something that happened at the store level?
I'd love to tell you that was isolated, one manager, one store. That's one example I shared. So there are many. These practices weren't just here in Texas. They were nationwide. They found tons of allegations of people saying things similar to that.
Well, you've talked about the Pregnancy Discrimination Act and what managers need to know, and of course the Civil Rights Act as well, when we talked about Bass Pro. Is there another example that you think would be helpful for managers to understand, to know a little bit about?
Yes, I think what's important is if you have one employee, this law applies to, which is the Fair Labor Standards Act, or the FLSA. So the FLSA is regulated by the Department of Labor, and that's the department and the act that establishes the minimum wage. So it also has rules against minor workers, or restrictions, I should say, around minor workers. And they also designate overtime, and that employees must be paid for all hours worked, and a ton of other stuff. But essentially, if you're paying an employee, even just one, this law applies to you.
And what are a couple of those?
The most common is what we talked about is minimum wage, right? What is the minimum wage? Federally, it's $7.25 an hour. And when does overtime apply? Federally, again, it's working over 40 hours in a work week. Should any hours over that should qualify for pay at time and a half of the regular rate. But some of the more sticky stuff that people think they know or maybe have the wrong assumptions about would be meal or break period. Often we'll get phone calls that say, hey, I should have two 15-minute breaks in an 8-hour workday, and I didn't get my 15-minute break today. And then they'll be surprised to hear, well, the FLSA doesn't regulate that. They leave that up to a condition and term between the employer and the employee. So if your employer has a rule that says, after 4 hours you get a 30-minute lunch or you get an hour lunch, that's up to the employer. What the FLSA says on a federal level is, I have to pay you for all hours worked. So if you work through that lunch hour, you don't get that break. It's compensable time.
What can a small business owner do to avoid problems in this area?
So for the FLSA, I would say that it starts at the beginning, just like most of these laws, and really figure out if an employee is classified correctly as either an employee or an independent contractor. A lot of times I'll hear this person is being paid $10.99, and when you start doing some digging and you kind of ask some questions, you're like, oh, I actually think that person should be an employee, get a W-2, not a $10.99.
If I'm a small business owner, and I don't want to violate the Fair Labor Standards Act, of course, are there any tools that I can use that might make it easier for me to keep track of all of the time that's worked and the hours that have to be compensated and how they have to be compensated?
There is. The DOL on their website has a lot of tools. They have for employers and employees. So on the employer side, they have a ton of fact sheets that you can read through on various topics. So if you want to know if someone's an independent contractor or an employee, they have a fact sheet for that. If you want to know what the overtime is or what the youth rules are for minor workers, they have all of that information on their website. For employees, too, they have information. They have an app, believe it or not, that an employee could download on their phone and track their time. This app will tell them if they should be getting overtime or not for that work week, and it'll help them track their hours.
Okay. Now, you also mentioned properly classifying your workers. I think this is a really big one. The exempt versus the non-exempt, the independent contractor versus the employee. Tell us what the issue is there, what the problems are there, and why it's so important for a small business owner to get this right.
Sure. When classifying employees, HR managers need to make two considerations, wages and job duty. So those two things must be considered in tandem. So you can't just fulfill one of the tests. So if an employee is going to be an exempt employee, which means they're exempt from the overtime regulation and minimum wage, they have to fulfill both. So they have to meet a salary basis test, meaning they have to make at least $4.55 a week or more in a salary. And secondly, they have to meet a duties test. And that is the more complicated piece of it. And I think a lot of times what will happen is employees don't even know what that means. What is exempt, what is non-exempt? And then you'll find some managers who don't even know what that means. And the truth is, if you're ever in doubt, if someone's classified properly, it's always safer to classify someone as hourly non-exempt.
Well, let's talk about independent contractors and employees.
I think that simplest way to put it is that a true independent contractor is someone who is running a separate business. A lot of agencies consider a variety of facts to determine whether a worker is truly running a separate business or not. We also have a quick questionnaire that we could provide our clients with to help them determine whether someone's an independent contractor or they should be an employee. But some common quick questions could be, does the employee have the right to control their work? Where do they go? When do they go? Do they use their own tools? So if you're actually giving a person a schedule, telling them you have to be here between 8 and 5 p.m., you have a break here, and by the way, here's some tools to do that job. That sounds a lot more like an employee than an independent contractor. Another question could be, does the worker have an opportunity for profit or loss? If they do, that's great. Sounds like an independent contractor, and we can talk more about that. But if they don't have that opportunity for profit or loss, it sounds more like an employee relationship. One of the reasons they may prefer to hire someone as an independent contractor would be that they think, okay, I can just pay them a flat rate, and I don't have to worry about any of the protections and benefits that come along with being an employee. That's not in favor of the employee, though, because if you hire someone as an independent contractor, and they really should be an employee, this person is deprived from things like minimum wage and overtime. That wouldn't apply to them as an independent contractor. Workers' comp. They wouldn't be covered under a workers' comp policy if there were to be a work-related injury because they're not an employee. unemployment benefits. So if that at the end of that contract period they were to apply for unemployment benefits, the state would say, you weren't listed as an employee, what's going on here? So they wouldn't get it. Anti-harassment discrimination laws don't apply to non-employees. And then the right to form a union or collectively bargain wouldn't apply, and any other employer-provided benefits. So if they had pay time off policies, holiday pay, all those benefits would be deprived from this independent contractor for being misclassified.
And they also avoid certain taxes, isn't that correct?
Correct. So an independent contractor relationship, they're given a 1099 at the end of the year. It's upon them to file those taxes and do that.
But if they were filed as an employee, the company would have to pay those taxes themselves. They're responsible. And they'd also have to pay a portion of their Social Security.
Correct. Social Security would be part of that. And unemployment is what we talked about earlier.
It can be very expensive, as I understand, to make a mistake in that area. Is that right, Karla? Do you have any examples of maybe some things that have happened here in Texas with people who have misclassified independent contractors and employers?
Earlier we talked about why an employer may want to go this route because it looks like it's saving them money, but the fact is misclassifying an employee could be very costly. So in Texas, the first thing comes to mind is the oil and gas industry. They're very much accustomed to paying a day rate for people who go out in the field and work. And they're highly compensated. Employees never had an issue with it before until recently, where these people were saying, hey, I may have been highly compensated and paid this day rate and maybe even given an auto allowance and all kinds of other things, but it wasn't classified as hours worked and overtime. I should have been given overtime. So a lot of litigators took that on and were proactively seeking people to sue big oil and gas companies. Some have been successful. Some oil and gas companies have even changed their pay structure to avoid litigation going forward. That one was pretty interesting to see. Not a new industry. It's been around for a very long time, and these people were highly compensated. So to see wage claims come from people in that industry was quite alarming.
So whether we're talking about the Pregnancy Discrimination Act, the Title VII of the Civil Rights Act regarding retaliation, or the Fair Labor Standards Act, where we talk about employees who must be compensated, classified properly as exempt or non-exempt, or as independent contractors or employees. If I'm a small business owner and I'm listening to this podcast, what would be your advice to me to make sure that I'm handling all these and complying with these regulations?
To know what the laws are and to be compliant with those. They're ever-changing, so make sure you have a good training program for your managers so that they can stay fresh on what the laws are. As we talked about earlier, there could be things like ban the box in a different city that you operate in that you need to know about. To be fair and consistent, applying discipline or when hiring, those kinds of things. Again, staying out of trouble for those biases. If you hear someone saying something's unfair, listen to them. And to seek help when in doubt. Call your HR business partner at eESI and ask for help. Even if you think you're on the right track, we're here to help. Maybe you are on the right track, or maybe we thought of something you hadn't. And then, of course, if ever necessary, we'll let you know if we think we need to get some legal counsel involved.
Karla, thank you so much for your time, and we look forward to talking to you again.
Thank you.
Our special guest today has been Karla Saenz, an HR business partner at eESI, and our subject was, why is HR so hard? Karla elaborated on some of the issues that can sometimes make HR complicated, and she also offered solutions. If you are a small business owner, it is critical, as she said, that your managers know and understand the laws, the risks, and the established company processes for dealing with employee issues. Working with an HR business partner like eESI not only helps you formulate the right policy manuals, forms, and processes your managers need, but it also provides the ongoing training necessary to mitigate potential risk and liability. But an eESI business partnership can also do a whole lot more, like help you hire top talent and provide your business with a Fortune 500 benefit packages necessary to attract and retain that talent. It can provide insurance specific to your company needs, handle payroll, in addition to keeping you compliant with the dozens of state and federal laws. It can even provide working capital at low interest rates quickly when you need it. All this and a lot more. If you would like to learn more about partnering with eESI, simply call 210-495-1171. That's 210-495-1171 and ask for an HR business partner. Thanks for listening to today's podcast. We hope it clarifies the HR process for you, all part of our goal at eESI to simplify business.